is not a subset of the power to set aside the award, my lord. My lord, it is my most respectful submission for your lordship's consideration that there is an inherent flaw in that argument where one starts looking at the power of setting aside as a larger power and the power of variation as a smaller power, my lord. As a matter of arbitration jurisprudence, my lord, according to me, my lord, I may be wrong, I'm submitting for your lordship's consideration, my lord, according to arbitration jurisprudence, my lord, that is an incongruent and unbelievable argument, my lord. My lord, the first test, my lord, there are two propositions that I rely upon, both theoretical arguments, my lord. My lord, the questions before your lordships are based on the scope of Section 34 of the Arbitration Act as it stands today, my lord. It is my respectful submission that the scope can be tested based on application of two doctrines, and according to me, you apply those two doctrines and you get the full answer with respect to the scope, my lord. My lord, the first doctrine that I would request your lordships to consider and test the application of is the doctrine of merger, my lord. According to me, as per settled judicial precedent of this honorable court, the award does not merge with the Section 34 order. The Section 34 order does not merge with the award. That is the position in Kunaiya Ahmed and several other lines of cases. I will just show 4 paragraphs. They are very clear. In the absence of merger, my lord, the jurisdiction under Section 34 is only an annulment jurisdiction. My lord, it is like using a sledgehammer to get rid of the award in full terms. Or like saying, I will use a scissor and cut out the diseased portions of the award. What remains still is an award, and what remains as the remainder of the award remains enforceable if your lordships exercise severance jurisdiction. But variation jurisdiction, my lord, is changing the nature of the award, and without a doctrine of merger supplementing the order under Section 34, what will become enforceable after this minor variation is full of difficulties, my lord. Let me give an example, my lord. The award says post-award interest of 16%. And your lordships do nothing but say, we don't interfere with the award. In section, not your lordships, but your lordships can do anything. But a court under Section 34 says, we don't interfere in the award. We are only making 16%, 12%, my lord. That is all. My lord, doctrine of merger does not apply based on the common law principles that your lordships have upheld in Kunaiya Ahmed. And there is no statutory scheme, as my learned friend pointed out, there is no statutory scheme that says that the order of 34 will merge with the award. My lord, in all other jurisdictions, I will give a table. Statutory provisions, wherever there is a power of modification, statutory provisions saying that the modification will merge with the award. So if common law doctrine, as per Indian law, does not apply for merger, and there is no statutory scheme to merge the order under 34 with the award, what remains enforceable, my lord, is a strange concept, my lord. The award remains enforceable as modified, but there is no merger. There is no merger. So, my lord, I find that very difficult. My lord, my first reason of saying that there is no merger, your lordship may just read 4 provisions of the act with me, my lord. Just 4 provisions of the act. My lord,
you are appearing in a case of international award or the Indian award?
My lord, I am appearing as an intervener on behalf of IRCON, my lord, because we are facing similar questions in domestic awards before the...
But tell me one thing. As far as merger is concerned, in a domestic award, there will be no difficulty. Merger, doctrine of merger with the Kunaiya Ahmed or others has always been a nebulous doctrine, which has its limitations. And because what merger does is the cause of action merges, the original cause of action merges, which led to the award. And any modification made, whether it's by way of reference or otherwise, you can always regulate it by that, because it's a doctrine of merger is not a statutory doctrine, it's a
common law doctrine.
It's a common law
doctrine. Lord,
has limitations.
What I'm trying to...
Whenever we evolve the law, the doctrine will make its way. Will not comfort itself.
I take it, my lord, and I will answer that. What your lordships are perhaps saying that if your lordships read into Section 34, the power to vary...
No, we're not even saying that. Doctrine of merger being a common law doctrine, it will be only applicable to the extent it does not come in conflict with the judgments of the court.
My lord, that is what I am submitting, my lord, that the doctrine of merger as per Kunaiya Ahmed can never apply to an order under Section 34. Tests are laid down, all tests are failed.
So that means you can go for fresh arbitration?
That is right, my lord. That is right.
No. Even after the award, you can go for fresh arbitration?
No, my lord. My lord, with respect, my lord.
Because the award is the cause of action. What res judicata, principle of res judicata is also based upon doctrine of merger.
Yes, my lord.
And the merger, once the award is passed, once it's not final and binding, res judicata doesn't apply.
Yes, my lord. My lord, may I answer this theoretically straight away, my lord?
Right.
My lord, I will answer. My lord, I will answer this straight away, my lord. Straight away, my lord. There are two things, my lord. If your lordship say that the power to vary the award exists in under section 34,
If the setting aside exists, that power is subsumed.
supposing, my lord, I'm assuming for a moment that your lordships are inclined to hold that, or your lordships are thinking of it.
Question.
Obviously, my lord, your lordships will have to say then that there is merger. I accept that, my lord. Your lordships will have to
Obviously,
say.
that
Obviously,
say the order which is enforceable will be the order of the court.
yes, my lord. My lord, if your lordships say that, my lord, it would be two things, my lord. First, my lord, it would be contrary to the scheme of the act. I will read four provisions to show that, my lord. Two, my lord, it would be contrary to the principles in Kunaiya Ahmed. I would read two paragraphs to show that, my lord. And third, my lord, it would disregard that all international jurisdictions where a right to vary has been given have statutory scheme of merger, which our act does not have. 3 points I've made, my lord. They are part of my proposition.
Okay, let's see.
Your lordship may first see, my lord, section 5. I will not read anything, my lord. I just want to show that section 5 starts with not, my lord, notwithstanding anything contained in any other law for the time being in force, my lord. Settled principle, KSL, Arihant, and every other law, my lord. Your lordship has to read this to mean notwithstanding anything contained in CPC, notwithstanding anything contained in 151. My lord, that is what my submission is, my lord. The scope of interference by the court is limited to the manner in which it is prescribed. Your lordships may now have section 34, my lord. Section 34 provides recourse against an award. The recourse of a court against an arbitral award may be made only on an application for setting aside the award in accordance with the following. My lord, your lordship, this provision has been read time and again. Your lordships are aware, amongst other orders, 34, 4 order can be passed remitting the award. After this, my lord, your lordship may see 35. 35 says, subject to this part, an arbitral award shall be binding on the parties and the parties claiming under them. So, according to me, the only effect of section 34 can be, it will hit at the finality of the award. Whether the award will exist or it will not exist, the court can apply a principle of severability to say that I will sever a deceased part of the award, my lord. That is a separate doctrine, my lord. That does not even require merger. It will fall within the scope of section 34, a doctrine that will apply to any annulment jurisdiction, my lord. But, my lord, what is very important, your lordship may see section 37, 1.3, section 31.
Check this out. I'm going to show you.
There is power of
Covered by, if it is covered by 37, if it's covered by setting aside, then it will be covered by 37.
Well, that is what
If it is not covered by 37, if it is not covered by setting aside, then the appeal will not lie before the division bench, it will lie before the Supreme Court.
Yes, my lord. So two things will happen. Two things, my lord. My lord, two things will happen. Your lordship will have to read the power of variation within the power to set aside or refusing to set aside. There is no power to uphold, my lord. This does not say that the court has a power to uphold. It will have to be read into the power of setting aside or refusing to set aside.
Right to that.
My lord, therefore, my lord, three things will have to be done. The power of variation will have to be read not only within power to set aside and refusing to set aside, it will have to be read within the expression set aside in section 34. And, my lord, under section 35, the award will also have to be read as an award as modified by the court under section 34. Three, my lord, what is being asked, what your lordships are being asked to do, my lord, is to read three jurisprudential concepts into powers under section 34, into powers under section 37, and into powers under section 35, my lord. My lord, if, first of all, my lord, I think, my lord, that is too much of a stretch that the other side is asking your lordships to carry out, my lord. But if it was jurisprudentially permissible, my lord, your lordship may see, if I am able to show based on Kunaiya Ahmed to your lordships that the principle of merger does not apply, then whether your lordships should read a power of variation into 34, contrary to the settled principles of merger under Indian law, is also a question that your lordships will have to answer, my lord. Your lordship may see Kunaiya Ahmed, what your lordships have held, my lord. It is a part of my compilation, my lord. Compilation volume 3, my lord. If your lordship would please have paragraph 18, my lord, starts at page 1895. My lord, I'll just be very brief on these cases, my lord.
Pashwanda, 1 minute before you go there. What happens if instead of resorting to 34.4, a party says, cut the matter short, I am not pressing that claim with the 34 court. He says, I don't want to even take that chance, I am running against time. 34.4 may happen, may not happen. I am interested in sustaining the award I'm not pressing that claim to the court.
My lord, that is what I am saying. My lord, your lordship.
What happens?
Yes, my lord. Your lordship's question presupposes that 34-4 is a view that the court has taken with respect to a part of the award. Three
Not
claims.
34-4. Before going into 34-4, the party which has got the award says, much haggling is going on this issue. I am not pressing that claim. This claim I am not pressing. According to you, the court can't even record, not pressed and sever it.
My lord, it can. My lord, my position is very clear that when your lordships are going to sever an award,
No.
the severance jurisdiction is a...
Let me put it slightly different. Suppose the claim award is 1 lakh, the party says, okay, I'll accept 50,000.
My lord, your lordship would be recording a settlement. It would,
Then enforcement,
my lord, conceptually, my lord, it is impermissible under the Act, my lord. Conceptually, it is impermissible under the Act. My lord, I say that, my lord, that is a difficulty. My lord, I'll just answer that. My lord, what I am submitting is slightly different, my lord. Your lordships will be faced with three situations. Three situations, my lord. Your lordships, let us talk only of the interest, my lord. Your lordships have a situation before you where your lordships feel that 16% or 26% interest post-award is extortionate. It satisfies the test of setting aside. My lord, what your lordships can do without doubt is set aside the award only with respect to post-award interest. It does not need to merge with the award. Your lordships have used a scissor and cut the last 4 pages of the award.
and what happens to the party? You'll have to go and re-engineer that portion.
That is the scheme of the Act. With respect to post-award interest, the matter has been relegated as if the parties never arbitrated, and it is open. Your lordship's findings will be res judicata as findings of your lordships sitting independently as a court. But there would not be a merger of your lordship's order under section 30, the court's order under section 34 with the order, with the award, my lord. My lord, your lordship may.
Consent. How do they record consent? In what form? Will there be a consent decree?
My lord, as I said, my lord, it is a
Award enforceable as per CPC under 36(1). The enforcement is in accordance with the provisions of CPC.
So that is how, so then it will be enforced. The judgment will now be the form of the decree and that will be enforced. So whether it is consent, whether it is unilateral giving up, whether it is court fine-tuning,
Enforcement will be as per CPC.
my lord,
But only enforcement will be enforced.
if we just put this in extremes, in binaries, one way or the other, then all these problems, you see, arise. After all, what is this arbitration? You have to keep 28 of the Contract Act in mind.
my lord,
A limited exception was made not to go to the courts of the country because it's a judicial procedure agreed by the parties. Now you come back and say that even this can't be done because the award is what can be enforced, and if the court even on a giving up modifies, it loses the sanctity. Internationally, it will not be treated as award.
My lord, I may come back to your lordships on the issue of settlement. Your lordship may give me a few minutes. Let me reflect on it, my lord. But what I'm submitting is slightly different. Your lordship may consider this, my lord. First of all, my lord, I have no difficulty with the concept of severance because I believe that severance is a subset of annulment jurisdiction.
That you understood. So that's over. Now the only question is, one, variation, even of typographical errors, calculation errors, you say is not permissible. Two, you say patent illegality or conflict with fundamental principles of law, again, not permissible.
Do not buy new windows.
My lord, that is my submission, my lord. The very purpose of Section 5 is to limit the interference of courts in arbitration proceedings. My lord, may I put it slightly differently? My lord, perhaps I'm just hoping, perhaps this will...
Doubts on doctrine of merger, suppose?
My lord,
Suppose it is said that the award holds that the claims are within limitation. The court finds it patently barred by limitation and therefore sets aside the award. Correct?
yes, my lord.
Will doctrine of merger not apply?
No, my lord, the award...
Then
My lord,
can file a civil.
yes, but I'll answer that, my lord. I'll answer that, my
Then
lord.
where is res judicata? Because
Res
someone-
judicata, my lord, I'll just answer, my lord. The determination made by the court as a dispute between the parties in Section 34 jurisdiction will stand alone and independent and hold res judicata. It will be a determination made by court in a dispute brought before the court by two parties, and there will be principle of res judicata with respect to that determination. Issue is stopped also.
Res judicata is based upon doctrine of merger.
Yeah, my lord.
That the original cause of action
Yes, ma'am.
gets subsumed. It's a part and parcel of the judicial order. Therefore, you can't rely upon the original.
May I answer that, my lord? Your lordships are talking about a situation, your lordships have put to me a situation where your lordships have held that the award is with respect to a claim that is barred by limitation.
That's an example.
Yes, your lordship may see that example, my lord. The effect of that set-aside order will be two things, my lord. That the award has ceased to be in existence. As a result of the award being ceasing to be in existence, under section 43(4), it might be open for the party to re-agitate, but your lordship's determination in the 34 court will be res judicata and issue estoppel between the parties. It will not be merger. It will be an independent doctrine of res judicata and issue estoppel arising from a court proceeding that has taken place because the award is effaced, my lord. It has ceased to exist.
In the example of the Honorable Chief Justice,
Yes, my lord.
if after limitation has been held as a ground to set aside the award,
Yes, my lord.
a section 11 is filed, High Court or here, depending on the nature of the arbitration. That stage you can't go into res judicata.
Of course, my lord. If the award is not a live, if the claim is not a live claim, I will show a judgment and say, my lord, this is the only claim.
Say, let us see the pleadings and the order, etc.
My lord,
Then,
my lord, but first two things, my lord. Fact-dependent cases should not impact the underlying jurisprudence of arbitration, my lord.
no, you are saying on the merger. See, it all took off on the doctrine of merger. So, that is where it was pointed out.
Three-
What happens in these kind of matters?
My lord, three facets. My lord, before I test, my lord, before I take your lordships to Kanhaiya Ahmed, that takes 2 minutes, my lord. My lord, the scheme of the act is your lordship has a jurisdiction to set aside, the court has a jurisdiction to set aside or refuse to set aside an award. After setting aside or refusing to set aside an award, impact only on finality. If your lordship says set aside the award, finality goes away, and under section 43, my lord, section 43(4), parties are free to arbitrate. My caveat is that it does not take away the determination of of the court with respect to res judicata and issue estoppel. Those will bind in subsequent proceedings. Now your lordship may say Kanhaiya Ahmed, please, my lord. Your lordship may say Kanhaiya Ahmed. It is in volume 3, page 1895. 3 paragraphs your lordship may see. So I'm so sorry, my lord. My lord, it is page 1918, my lord. I'm so sorry. Volume 3, page 1918. Well known judgment, yes. 3 judges of this court, my lord. 1918, volume 3. My lord, in my note, para 7, my lord.
Yes.
My lord, in my note, para 7, the paras that I'm reading are, my lord, para 7 to 12 and then 42 to 44. My lord, your lordship may please have paragraph 7, my lord. Your lordship has it. My lords have it, my lord.
Every Medicare recipient.
My lord, as far as my submission is concerned, with respect to no power of variation, it is pivoted on no merger, my lord. That is why I'm saying that if your lordships conclude that there is merger with respect to no power of variation, this is my only argument. Your lordship may now see, my lord. My lord Justice, my lord the Chief Justice has it.
Yes, please. Right.
My lord may see paragraph 7, my lord. The doctrine of merger is neither a doctrine of constitutional law nor a doctrine statutorily recognized. It is a common law doctrine founded in principles of propriety in hierarchy of justice delivery system. On more occasions than one, this court has had an opportunity of dealing with the doctrine of merger. It would be advisable to trace and set out the judicial opinion of this court as it has progressed through times. And then the case is quoted, my lord, CIT versus Amritlal. There can be no doubt that if an appeal is provided against an order passed by the tribunal, the decision of the appellate authority is the operative decision in law. If the appellate authority modifies or reverses the decision of the tribunal, it is obvious. My lord, reversal on merits is very different from annulment, where all that the court is saying, the award ceases to exist, you go back and arbitrate. Here it is saying modifies or reverses the decision of the tribunal. It is obvious that it is the appellate decision that is effective and can be enforced. In law, the position would be just the same, even if the appellate decision merely confirms the decision of the tribunal. As a result, there is no confirmation under the Act also. as a result of the confirmation or affirmance of the decision of the tribunal by the appellate authority, the original decision merges in the appellate decision, and it is the appellate decision alone which subsists and is operative and capable of enforcement. Lordship may come to placitum F onwards, my lord, same page, my lord. While doing so, this court analyzed several provisions of the Income Tax Act so as to determine the nature and scope of the relevant appellate and revisional powers, and held, my lord, this is important, if the subject matter of the two proceedings is not identical, there can be no merger. In state of Madras versus Madurai Mills, this court held that the doctrine of merger is not a doctrine of rigid and universal application, and it cannot be said that whenever there are two orders, one of the inferior authority and the other of the superior authority, passed in appeal or revision, there is fusion or merger of the two orders, irrespective of the subject matter of the appellate or revisional jurisdiction, revisional order, and the scope of appeal or revision contemplated by the particular statute. The application or doctrine of the doctrine depends on the nature of the appellate or revisional jurisdiction, or order in each case, and the scope statute.
We have understood this because paragraph 12 makes it clear. Look, as we say, initially, it's not a statutory doctrine, neither a constitutional doctrine, it's a common law doctrine. It depends upon facts and circumstances of the case. If the section 34 is to be, we'd not like to bring in the income tax matter. Why it becomes important is because there are multiple stages.
Yes, Mr.
There are multiple stages, and difficulty which arises sometimes is a portion of the appeal is decided, portion is demanded. Therefore, that doctrine of merger over there becomes very important.
My lord, may I
There's
just read a
63 powers are there, 148 powers are there, where particular portions are taken into
May I
account.
just read a few lines from 42 and 44, my lord. Just a few lines, my lord. And then I will move to my next point, my lord. My lord,
The time is getting over now.
my lord, may just bear with me for 5 minutes, my lord. My lord, to merge means to sink or disappear in paragraph 42, my lord. To merge means to sink or disappear in something else, or to become absorbed or extinguished. To be combined or swallowed up. Merger in law is defined as the absorption of a thing of lesser importance by a greater, whereby the lesser ceases to exist, but the greater is not increased, and absorption or swallowing up so as to involve a loss of identity. We may look at the issue from another angle. The Supreme Court cannot and does not reverse or modify a decree or order appealed against while deciding a petition for special leave. The court held that a mere permission leave to appeal, it does not result in merger, because we are not exercising identical jurisdiction as other courts. Yes,
Therefore, there was a further reference,
Yes, ma'am.
another decision.
Well, if your lordship were
Even
to,
can be filed before the High Court. Correct. Doctrine of merger doesn't apply. Correct.
well,
It will be on several grounds, it does not mean that we have affirmed them.
well, if your lordships were to hold that section 34 includes within its scope the power to vary, then your lordships will have to hold that under 35, award includes award as varied by the court.
Correct.
Under 37, your lordships will have to hold that the
You're right to that extent, you're right.
One more thing, my lord. Your lordships will then be doing that in the absence of similar provisions as exist in other international statutes.
Something different, we have to look at our statute, we can,
Lord,
if you know our circumstances, look, if you know our circumstances, if we find there is a scope for that, we'll see.
All I
We
wanted,
may be guided by the international jurisdiction, but they're not binding on us.
my lord, all I wanted to say is I've given a table. All other jurisdictions where power of appeal modification is given. My lord,
I have been saying,
When to apply, when not to apply is also with us.
yes,
my lord,
I have been saying this not since long. Why being slaves of the forest?
No, there's no question. No, please. Mainly because we apply, we are not slaves, certainly not. We apply with our consequences in mind.
Yes, persuasive,
They are persuasive.
but it should
Not binding. Light from all sources.
Sometimes,
Light from all sources.
yes, but
You have also right the arguments on other jurisdictions.
sometimes it is to be more binding than
Than Indian rules.
my lord, I'm moving to my next point, but your lordship may just test my argument on one conceptual basis, my lord. My lord, there is one situation in which I submit that the decision of the 34 court would be res judicata on its own terms without merger because the award has ceased. And the other argument, my lord, that comes to me is no, it results in merger and then it becomes res judicata. My lord, if it results in merger and then the decision becomes res judicata, then nothing remains for the purpose of 43(4) to adjudicate.
No, that's a statutory rule.
My lord,
That's a common law doctrine, that's a statutory
my lord,
rule.
if the cause of action, my lord, I say that if the cause of action has merged in the order under 34 and that has become res judicata, then 43(4) becomes irrelevant. My lord.
It depends upon, it all depends upon the nature of order passed under 34.
My lord, I've now come to my second proposition, which will take 3 minutes, my lord.
How to take a freezing 43-degree room.
My lord, your lordship may come to paragraph, please come to paragraph 15, my lord. I wanted to say, my submission is this, my lord. Even if I say that annulment jurisdiction is very different from appellate jurisdiction, variation jurisdiction, my submission is they are chalk and cheese. They cannot be mixed, my lord. There cannot be merger. Even in that case, my lord, the principle of doctrine of severability can apply to say that I will not annul the whole award, but I will only annul separable parts of the award. And that, my lord, is a use of a smaller power subsumed within a larger power. There, your lordship's principle that was put to me will apply. That is dealt with in my second proposition. My lord, I wanted to submit this, my lord. Your lordship will see in paragraph 15, I have referred to a case called R.S. Jivani, my lord. This was a full bench judgment of the Bombay High Court, my lord. 3 judges who eventually became judges of this honorable court, my lord, full bench decision of their court, which held there is no power of variation, there is no power of modification, but power of severance exists. And they applied doctrine of severability to set aside, answer a question that separable parts of the award can be set aside. Your lordship may conceive 3 situations that I'm putting before your lordships, my lord. My lord, an award will be an award where there is liability and quantum decided. There is a breach of contract and I give you 100 rupees as damages. The principle of severance, my lord, severability can say, I will uphold the award on liability, that you have breached the contract. But 100 rupees is not the right amount of damages. I'm setting it aside, and that can go back to arbitration. We see it every day, my lord, in international arbitration, in domestic arbitration, that awards are separated on liability and quantum. Liability is upheld, quantum is set aside, and quantum goes back to arbitration, my lord. That is one situation. The other situation will be, my lord, where 3, 4, 5 claims are decided together, but one claim stands independently and can be set aside. For example, my lord, a person makes a claim for loss of profits for a premature termination of a contract, says my contract was terminated 12 months earlier. During that period, he also makes a claim for escalation. And the arbitrator awards loss of profits as well as escalation. And your lordship say escalation is covered. If I've given you loss of profits, it's covered for those 12 months. My lord, in that case, the claim with respect to escalation can be separated and the award for loss of profits can be upheld, my lord. That will be the second situation, my lord, in which there will be a severance of the award, my lord. And the third, my lord, classic case of interest. Your lordships find that interest is extortionate. It is within your powers, my lord. I'm so sorry, my lord, within the powers of the section 34 code to say, I set aside the award on interest. Then your lordships can even exercise, if one of you are willing to agree, I will send you back to the arbitrator and he can cure this, in my view, that this is extortionate. But your lordship cannot change the rate of interest, my lord. That is my position. That variation cannot take place. What I wanted to submit, my lord, is that the full bench decision in R.S. Jivani was relied upon in the division bench judgment of Puri construction of Delhi High Court in division bench, which is referred to in paragraph 16, my lord. In Puri construction, the award of liability was upheld, that you correct, this party was in breach of contract, but the entire award on quantum was set aside, saying that we are setting aside the award on quantum, thereafter we are leaving you free to decide and assert your rights in accordance with law. Both, while doing so, my lord, Puri construction relied upon R.S. Jivani's case, my lord. What I am submitting, my lord, is that this Puri construction, where it relies upon R.S. Jivani, was affirmed in Hakim in paragraph, my lord, 30 and 31 by your lordships, my lord. So therefore, my lord, my submission is, in paragraph 30 and 31, Hakim has noticed Puri construction, and your lordships in Hakim have noticed R.S. Jivani, and your lordships have impliedly affirmed the principle of severability of an award. But I repeat, my lord, severance is very, very different. Severance is an annulment jurisdiction. It is very different from an appellate jurisdiction, my lord. I again say, my lord, that it may be, according to me, it may be a bit of a stretch to say that a section 34 order, when the word appeal where is not used, is intended to merge with the order because it is only an annulment jurisdiction. That's
Justice,
much grateful.
you are just 1 minute. Please, get it back.
Just 2, 3 small points, my lords. Everything else is covered by the arguments. My lords, the statement of objects and reasons was read by Mr. Kripal this morning, but paragraph 3, my lords. Just paragraph 3 I want to put.
We have read it, we have read it.
Yeah. My lords, it says that the institutional model law and rules are intended to deal with international commercial arbitration and conciliation. They could, with appropriate modifications, serve as a model for legislation on domestic arbitration and conciliation. So, my lords, legislature had the power to make some modifications. And 4, Roman 1 says, the main objectives of the bill are as under to comprehensively cover international commercial arbitration and conciliation as also domestic arbitration and conciliation. So, my lords, the institutional model law was adopted as it is. But subsequently, there have been 2 amendments, 2015 and 2019. So, whenever the legislature felt the need to bring in some amendments, that is. And my lord, second point is that under 34(4), my lords, my submission is that the awards which are patently illegal or which are against the basic framework of the Indian law or something.
I can't get hard. No.
Right. And therefore, my lords, the power of modification would not come. Otherwise, my lords, if you go into the power of modification, then, my lords, the court has to necessarily go into the merits of the case, reappreciate the evidence. And in that case, my lords, so just one example I'll give. The arbitrator awards compensation for 12 months delay. The court may, in a given case, say, no, it's not 12, it is 10. They'll pro rata reduce it. The court may say it is not 12, it is 16. They may pro rata increase it. So, whereas modification would then impinge upon explanation 2 and 34(2)(a). So, therefore, my lords, modification is fraught with all dangers and therefore it should not be allowed. I have to submit only this one. The rest is all covered by her. I'm highly obliged, my lords.
We'll just take 2 minutes. Just a few minutes. I want to show one judgment, Lord, which is there in the McDermott case. It says with the question that came from Lordship as to what happens in a situation where the award is set aside. Lord, para 52 of McDermott says that the parties have the right. Lord, in my submission, the real problem that has to be addressed is how the second part has to be solved. How the part as after setting aside has to be dealt with. If we start finding solution in modification and varying, the solution will start becoming a problem. Lord, there are 4 situations. Yes, Lord.
Already argued.
Lord, therefore, Lordship may only consider one thing. Is the power to set aside, please see A and B. 34(2) has 2 parts, A and B. A, nothing can be modified. It can only be set aside in A. That is, when the arbitrator is incompetent, when the matter is beyond reference, there's nothing for Lordships to modify, or the 34 court to modify. In B, also, there is nothing to modify. It at best can only be related to C. Now, Lord, if defect can be cured by modifying or varying, that means that defect, actually the defects are such that they cannot be cured. Now, the only problem that remains is with respect to interest or at best costs. Lord, 3 things Lordship may consider because interest and cost is something that always bothers everyone. Lord, first point, in interest, the date when the interest has to start, the quantum on which interest has to start, the rate at which interest has to start. These 3 things, Lord, many a times, the 34 court may not have the data, the full details available with them to be able to grant or reduce or reject the interest. Lord, we have large number of cases where interests are refused. We file a section 34 challenging the refusal of interest. What is the order that Lordship would consider, 34 court would pass? Okay, the rejection is incorrect, but you go back to the arbitrator who can reconsider your interest. Or would the 34 court now start looking at all the materials on record